My country people, now see this video where they up of my head, so I want to release and make it play. I beg, just help me share me react. APC and co they plan for integration where we say no go happen. Matter where we say still day court. I want it possible. I don't want to talk too much. I might leave the video. Make I want release the sound now. Beg, help me react, me you share, then comment. Me you react to comment. Just watch to the end. Watch to the end. Me you hear this info. Oh God, oh. Watch to the end, my people. This matter is very serious. If you know say you be obedient worldwide, you know say because all of us will be what they hope for new Nigeria. This video you need to watch until the end. May you fit get the information. You hear me, so share me, you react. I don't want to talk too much again. I beg.
Many things have happened since the February 25th elections have produced the All Progressive Congress candidate Bola Ahmed Tinubu as president-elect. The PDP and the Labour Party's candidates have since filed a petition challenging the victory of Tinubu at the Presidential Election Tribunal. The electoral umpire, the Independent National Electoral Commission, is also out to defend its election as free, fair and credible enough to be trusted and respected. The commission, through its lawyers, has described Peter Obi's petition as abusive and incompetent. INEC's attorney, Abubakar Mahmood, further labeled the petition vague, non-specific and hypothetical. As the legal juggernauts go to battle and post-election fireworks take up the polity, we analyze and unpack the petitions and what they mean to Nigeria's electoral viability. Now, joining me tonight and PhD to discuss this is Dr. Omoshola Deji, a political scientist. Good to have you, Dr. Deji.
Thank you for having me.
Now, let's start off with this. Can you explain INEC's position as the electoral umpire regarding the allegations of non-compliance with electoral laws and breach of its own guidelines in the last presidential elections? What is INEC saying?
Well, the opposition political parties are challenging the election based on substantial non-compliance, but INEC has responded saying that it has not breached any law and it has substantially complied with the electoral law and its guidelines. INEC is arguing that if there are any glitches, it is not substantial enough for the Presidential Election Tribunal to upturn the result as earlier stated by the body. So INEC is all out to defend what he has done as regards the presidential election that produced Bola Ahmed Tinubu as president-elect.
Now, I know you're not a lawyer, but what is INEC's legal argument that it intends to use at the as in its defense at the Election Petition Tribunal?
Well, INEC is saying that it has the liberty to determine how the result will be transmitted, and the electoral body is arguing that in this case that the Electoral Act does not state that the result should be transmitted maybe manually or electronically. That so INEC can choose any kind of any mode of transmission that it so wishes. But people are arguing, especially the political parties challenging the result, that you said in your guideline that you are going to transmit the result electronically. So INEC is arguing that, okay, even if I have not done that, it is still within my power to determine the mode of transmission, because the Constitution as the Electoral Act has given me the liberty to determine how to transmit the result.
Even
but
though
the argument
stipulated
now,
that in its guidelines.
Yeah, but the argument now is that can you now change what is in your guideline in the middle of an election? So that is left for the tribunal in its wisdom to decide that if a football match is happening and you have called both sides that, okay, this is going to be the rule of the game. So is it logical for you in the middle of the game to now change, the decision? And another thing is that can any reason be substantial enough, seen or unforeseen reason, for you to change the rule of the game? That brings us to the question that if there is a technical glitch, now what will happen? Is it within INEC's right to change the rule of the game as a result of the technical glitch? Then what constitutes a technical glitch itself? And if a technical glitch occurs, does it mean that INEC must wait for those things to be fixed? So INEC is saying that during the presidential election, that uploading the result via the IREF for the presidential election, that there were difficulty in uploading the result, and the manual mode, which is the alternative, has to be
so there has to be a fallback.
Yeah, exactly.
Yes. And also looking at these issues, and I'm sure the legal experts would take this up, the language, the semantics of guidelines. Those guidelines, does it imply a law? Is it cast in stone? And of how strong enough of a word is it to ensure that INEC stays with its guidelines or not?
Okay,
yes.
well, the guideline itself, it's very important, because that is what keeps INEC in check. Like, it makes sure that INEC operates within a specific rule. Now, you can decide not to kind of like have a baby. Government is not going to hold you. But once you impregnate someone or you give birth to a baby, you don't have the right to kill that baby. So the argument here is, okay, INEC, you can set the guideline based on your own liberty and resources and capacity and capability. But when the election is on, can you change the guideline at the middle of the game? So now, the problem is that we are having an election whereby INEC itself is being challenged to come and defend its own guideline. And that is a problem in this election. Past elections, we have a situation whereby political parties would challenge themselves. The action that was taken by another political party in terms of violence, in terms of overvoting, that is what is being challenged. But the significance of this presidential election tribunal is INEC itself is being brought to now defend its own guidelines. So that leaves much to be desired, because INEC as an independent body should be able to come up with a guideline based on the resources based on the resources provided to it, to make sure that, okay, this is what I can fulfill and state it. Not that you are going to state something and then at the middle of the game you try to do another.
Now, Dr. Deji, looking at this, what is the basis of the Action People's Party's challenging the results of the presidential poll? Because if you look at the Action People's Party, they're not a major political party to be reckoned with. So what's in it for them, and why are they challenging this presidential results?
Well, I think it's within the right of any political party that participated in an election, even if that political party has one vote, it is within the right, having participated in a process, to be able to question the process and the result that emerge from the process whereby you submit yourself to and participated in. So if APP has a candidate and participated in that election, of course they have the right,
of their position.
Regardless of their position, it is within their right to challenge. We've had situations in this country whereby political parties challenge election result because their name or their logos were tampered with. And if you look at the result of those political parties, it's little or nothing to write home about, but they are challenging that, okay, why should you deny us our right? So I think it is, yes, on principle. So I think it is within the right of APP to challenge the presidential election, and they are challenging it as well on the basis of INEC's conduct. And that is one of the things that gives me concern, because INEC is supposed to be an unbiased umpire. Now, what we have is that INEC, whether it likes it or not, becomes a biased umpire, because it now has to take a position. If we have a situation whereby it is among the political parties and INEC is just to tender evidence based on what transpired, was there overvoting? Come and testify. Okay. That is still logical, but a situation whereby
to put the umpire on trial.
Oh yes, on trial. So that itself leaves much to be desired in our electoral system. And if you look at it, the money that was budgeted for INEC itself, using technology, was what INEC sold to Nigerians for them to have about 300 billion naira of taxpayers' money for this election, and Nigerians bought into it. So if there were any glitches or anything, then you need to have maybe some people need to be standing trial now for misconduct. Because if you dash the hope of Nigerians, if you're a technological expert, it is expected that at such a crucial election, nothing goes wrong.
To whom much is given, much is expected, like we say. And one of the implications of what you just mentioned is also trust deficit among the Nigerian people. They've given financial support to the electoral umpire. And that's why we're discussing this issue at the presidential election tribunals. Now, I did talk about the Action People's Parties challenging this results. They're not the only ones challenging this results. They've received petitions from the People's Democratic Party, the Labour Party, the APP, the AA, and the APM. They're also challenging the election results. Now, are these petitions likely going to be different from the Action People's Party's challenge?
Yeah, it's quite different, and the prayers of the political parties to the court are quite different. Some parties are challenging the eligibility of the vice presidential candidate, arguing that he was nominated as a senatorial candidate, and at the same time he was nominated as a vice presidential candidate. And the Constitution and Electoral Act forbids you from having two nominations. So once you have two nominations, it is being argued now that, okay, you are not eligible, that, okay, if you try to hold two, then you lose both. Yes. You're only entitled to hold on to one and see it through. Once you attempt to hold two, you lose both. Then there are other arguments that about the president-elect, about his
so different parties with different arguments and prayers to the
exactly. And one of the prayers is even to nullify the candidacy of the president-elect itself, on the argument that, okay, he was indicted in the U.S. At some point as regards heroin-related cases. Now, the question is that, does an indictment amount to a conviction? And that is left for the tribunal to now determine whether, if you are indicted and you pay a fine, does that amount within our scope of law to a conviction? So if the tribunal in its wisdom so decide that it amounts to a conviction, then that is the
there
end.
There would also be other issues, jurisdiction. Where was it convicted? How long ago did this happen? So there are lots of issues to be unpacked in the election petition tribunal. Now, just to ask you, Dr. Deji, the swearing ceremony is billed for May 29th, just next month. And the courts have all of these issues that we just discussed to deal with. Is there a timing to it? Is there a time restriction to when they have to adjudicate to this matter, or it can go on regardless of if the president-elect is sworn in or not?
Well, when a president-elect is declared, if you are a party in that election, you can challenge the declaration in two different courts. The court of first instance being the court of appeal, which is now handling the case, called the Presidential Election Tribunal. If you are dissatisfied, then you can go higher to the Supreme Court. So you have two instances whereby you can challenge the result that was declared. So the appeal court, which is the Presidential Election Tribunal, has 180 days to determine anything that is brought before it. Before, now we used to have a lengthy amount of time, but the Electoral Act now has stipulated that it has to be 180 days. Now, if you are dissatisfied as a political party and you approach the Supreme Court has 60 days to now take a position. And the Supreme Court being supreme, their position now becomes final. Although it has been argued that whether 180 days is enough when you have cases that are of less importance and significance spending about 20 years in the Supreme Court, that, okay, how do you expect someone within 180 days, whereby you have different days to file and to file different motions, 5 days, 10 days and all that, and if you minus that from the 180 days, now how do you call witnesses across the length and breadth of Nigeria to come and defend in 180 days? But we also have lawyers that are arguing, such as Olisa Abiakoba, that even the 180 days is too much, that, okay, for fairness, for equity, for justice, that the court should be able to take a position before the president-elect is sworn in. But based on the gaps in our judicial system, that seems almost unachievable. Because, okay, even if the Court of Appeal takes a position, then what now happens if you decide to appeal the judgment of the Court of Appeal at the Supreme Court? That is another 60 days. So cumulatively, if you look at it, it takes
would not be possible to do that before
yes,
the swearing.
Exactly.
Yes. Now let's get back to the bone of contention. Why these political parties have gone to the Presidential Election Tribunal. INEC's lawyer, it's not every time, and I think it's quite unprecedented that the election umpire itself would be standing trial. Abubakar Mahmood, senior advocate of Nigeria, and also former president of the Nigerian Bar Association, insisted that it conducted free and fair polls on February the 25th. The election was free, fair, and credible, and in compliance with the Constitution of the Electoral Act 2022 and other relevant laws and guidelines. End of quote. I just quoted him. It's stated in one of the documents before the tribunal. Do you agree or disagree with this position? I do know that it's the court's responsibility that will determine, if these elections were truly free and fair. What do you make of the statement?
Well, if I'm to look at it from a personal angle, I don't think INEC complied with its own guidelines substantially, because INEC is bounded by three regulations for the presidential election. One is the Constitution of the Federal Republic of Nigeria, the second is the Electoral Act, and the third is the guideline. The Constitution is the ground norm. Now, the Electoral Act is seen as the voice of the people. Now, the people tell, because it has to be passed by the National Assembly and assented to by the president. So the National Assembly being elected representatives of the people, the Electoral Act is seen as the voice of the people, stating how they want whoever will govern them to come into power. So it is seen as the voice of the people to INEC, that, okay, this is what we, the people of Nigeria, want, haven't said it through our elected representative. And the president, when he gives assent to it, it becomes a law. Now, where INEC becomes independent is the aspect of the guideline. INEC will now come with its own guideline, which is the third rule. So INEC itself, it's not free to act as it so pleases, because it has to have a guideline. So,
and it was created as an act of parliament too. It's not independent of the law.
Yeah, so the guideline in this case is to now, is INEC telling us what it is going to do, so that we have something to hold INEC to. So if you have a guideline, that means you are telling us that, okay, this is how you want to go by this election, and we have something to hold you to. And that is why the political parties, INEC having allegedly failed to follow its guideline, the political parties are now holding INEC by the jugular, that you have failed to follow your own rule, your own guideline for the election. You promised us A, but you are delivering C and D.
How has INEC responded to that and not uploading the results on the IREV portal for the presidential elections immediately? What has been their response to all of these complaints by Nigerians? Well,
INEC has been saying, because INEC has to defend its own position. So INEC has been saying that she has complied substantially with the provision of the Electoral Act and its own guideline.
Okay, and still talking the presidential election petition tribunal matters before it. I still have in the studio Dr. Omoshola Deji, a political scientist. Now, looking forward and looking at the history of Nigeria, we've seen, the election that brought in President Buhari was quite unprecedented, and it was celebrated across Africa, a peaceful handover from one democratic government to another. And we had the famous phone call when former President Goodluck Jonathan placed that phone call to President Buhari to congratulate him. And people thought, it would be the right step to go in our electioneering process, that we're progressing. But now we've seen the floodgates of petitions and all of that. Looking into the future, what needs to be done and what lessons can we learn from this to avoid these cumbersome and lengthy court processes? And, elections are still over. But if you're a political scientist, you've been observing social media and even mainstream media, the sorts of rhetorics. It's like, look, this election is not over. People doubting the credibility of the electoral umpire and all of that. What must we do to improve our electioneering process and ensure that we don't end up in courts after conduct of any type of elections?
Well, I think the National Assembly has a major role to play, because if you look at the wordings of the Electoral Act, there is a section that says you can transmit or transfer, transmit and transfer, something like that. And you begin to wonder, what are you saying? Then what constitutes transmit itself? What do you mean by transfer? So I think...
Do you mean they need to be clearer in the language?
Yes, exactly. Yes. Like the language of the law needs to be clear, or maybe there should be maybe an appendix to the law for you to define that, okay, this is what we mean by transfer, this is what we mean by transmit, this is what we mean by electronic, so that we can avoid a situation whereby everybody has to now kind of like flood the court. When people flood the court, that means we don't have democracy, because the bane of democracy is that the will of the people. Now, what we have now is the will of millions of Nigerians having casted their ballot is now going to be determined by the court.
Meanwhile, it's INEC that should determine who. It's not the business of the court.
Exactly. So we now need to check our electoral system. Then I think that there should be consequence for actions, because we have a system whereby if anything happens, there's no consequence for
what type of actions are you looking at? Electoral offenders or INEC's conduct?
Electoral offenders, INEC staff itself. I want to see a situation that if the court so decide that INEC has not followed its own guideline, I want a situation whereby the decision makers at INEC itself should be standing trial before a competent court for failing to follow the guideline, because they are the people that made the decision. Somebody decided in the middle of the game that, okay, let's go manual in terms of the collation and the transmission of results. So if the court finds that, okay, that is wrong, I don't want it to end there. I want to see people responsible for that
level of accountability,
being prosecuted.
and I guess that would make the overall process improve. Now let's do a bit of reflection on INEC and the conduct of these elections. You have been, slightly critical of INEC's conduct, and you feel they can do better. So my question is, looking at the overall performance of INEC and the introduction of this technological shift, the BVAS and the IREV, how would you score INEC's performance in the scale of 1 to 10? And also looking at the results, because the BVAS is presented, the elections in the past, you see states coming with 10 million, 12 million votes. We're not seeing any of that. If you also look at the National Assembly, there are 109 members of the National Assembly. About 70+% will not be returning. And it means, it shows a lot. Governors have often used the National Assembly as retirement home, the Red Chamber, and a lot of incumbent governors, as powerful as they are, could not win their elections. So looking at these things that I just mentioned and the overall conduct of INEC, how would you score them? And would you say we're making progress with our democracy?
Well, if I'm to be a fair examiner, if I'm to score INEC, I'm going to score them in two ways. Pre-election and the electioneering itself, what happened on the day of election. Pre-election, I will score...
If you can in a minute, please.
Okay,
I really appreciate it. Yes.
Pre-election, I will score INEC maybe a 70, because the introduction of the BVAS, IREV, that is a tremendous improvement to our electoral system. But the conduct of INEC on the election day itself, based on its failure to address the the grievances that were stated by the political parties and just going ahead to declare the election, I will score INEC maybe a 30 or 40.
That's poor.
Yeah, yeah, it's poor.
And post-election, the way they've managed communication and all of that.
Post-election, the way they've managed communication, for the fact that INEC has failed to come out to Nigerians to state what actually happened. INEC should be able to communicate in a layman's language that ordinary Nigerians can understand. So we understand that this involves IT, but there should be a way you can communicate it to break it down to the ordinary Nigerian. I think INEC has failed in that regard. So for that, I'll still give INEC 40, sincerely.
Okay. There you have it, Dr. Moshola.